Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. First of all, sorry guys, I couldn't make any video within this month because I was on a vacation. So, let us move into the new topic, the concept of pari materia. The term pari materia has been derived from the Latin and it finds a prominent place in English law and Indian law. This term has been defined in Black's dictionary as on the same subject matter. This term denotes that two statutes, when they are pari materia of each other, they deal with the same subject in the same manner. We have a definition given here. When two statutes are pari materia of each other, they are all to be taken as one system to suppress the mischief. The two laws are only parts of the same provision. When a term is used without any clear definition in one act but is defined in another act which is in pari materia of the first act, the definition may be treated as applicable to the use of the term in the first act. So, pari materia is nothing but based on the same subject. That means a student can identify that numbers and formulas deal with mathematics, study of plants deal with botany, study of animals deals with zoology, etc. So, based on the subject, we can classify whether they are pari materia to each other or not. In the same way, the court also decides whether the two statutes will be pari materia to each other or not. Principles. There are certain widely accepted principles on which court of law has to decide whether two statutes are pari materia of each other or not. The first principle says that the chronological dates when the statutes were enacted and to see whether they are intended for the same purpose or not. In other words, whether the intended beneficiaries of the both statutes happen to be in the same genre or not has to be decided first. In case the intended beneficiaries happen to be the same genre of people, then the two statutes may be called as pari materia of each other, otherwise not. Here, we have to see the chronological dates in which the statutes were implemented, and these statutes are intended for the beneficiaries of the same people or not. So, here we have a case law, Employees State Insurance Corporation Madras versus S.M. Sriramulu Naidu. In this case, the defendant argued that the Factors Act of 1948 and the ESI Act, that is Employees State Insurance Act 1948, are pari materia with each other as they were enacted in the same year and both of them were intended for the benefit of the wage earners. The court of law, however, took a divergent view and held that these two laws were enacted in the same year. That is okay. And the intended beneficiary of the two acts were almost the same group of workers. That is also okay. But this alone did not satisfy the requirement of pari materia. The Factors Act was not only the beneficiary statutes, as such the whole purpose of this act was to regulate the working conditions in practice to protect the interests of the workman, and also the ESI Act, the Employees State Insurance Act of 1948, did not apply only to the factories but applied to the other commercial establishments also, and this was in the nature of the beneficiary statutes which aimed at providing insurance coverage to the workers. Hence, these two statutes were not pari materia of each other. So here what the first principle says that this Employees State Insurance Corporation, the ESI Act, is not only beneficiary for the workers, the factory workers, but also it applies to other employees also. So, here the Factors Act of 1948 and the Employees State Insurance Act 1948, they were enacted in the same year, but they are not going pari materia to each other because this ESI is not only exclusively working for the benefit of only factory workers but also for the other insurance workers also. So, here the the Factories Act of 1948 and the ESI Act 1948 are not pari materia to each other. The second principle says that it is not necessary that the two statutes were enacted in the same year or almost nearby years. So, if they want to be pari materia to each other, it is not necessary that they should be enacted in the same year. If they are going in the same subject, they will be pari materia to each other. So let us look into the another case law of Rais Uz Zama and another versus State NCT of Delhi. In this case, the Delhi High Court was called upon to decide whether the Explosive Act and the Explosive Substances Act are pari materia statutes. The Explosive Acts was enacted in the year 1884 to provide the comprehensive law regulating the manufacture, keeping, sale, transport, import and export of explosives. And the Explosive Substances Act was enacted in the year 1908. They have a huge gap of 24 years. The statements of the subjects and the reasons for the enactment of Explosive Substances Act 1908 records that the inadequacy in existing law, that is, the Explosive Act 1884 had been noticed while dealing with crimes committed by means of explosive substances, and therefore this new law was being enacted. Hence, clearly, these two statutes, though separated by many years, were pari materia of each other. So, both these two laws, the Explosive Acts and the Explosive Substances Acts, are being based on the same substance, what you call the explosives. So, they are pari materia to each other. Coming to the third principle, when two laws have come out of the same source, as in the case of Indian Sale of Goods Act and Indian Contract Act, because the Indian Contract Act is too wide and too huge, the lawmakers want to reduce the volume, and then obviously the Sale of Goods Act and the Indian Contract Act are pari materia of each other. Coming to the fourth principle, when a previous provision of a statute is incorporated in a subsequent statute, the meaning of that particular provision retains itself and same meaning is to be given in the subsequent act also. Let us take an example and let us assume that if there is an existing statute called 1965 statute and it has some sections, and sections 6, 7 and 8 of this law are later on incorporated in another statute which is in 1972 statute. Now the court of law wants to refer to the 1965 statute and look at other sections apart from 6, 7 and 8, because this 6, 7 and 8 are incorporated in 1972 statute. To have a correct meaning of these three sections, in this, is this permissible under the concept of pari materia? Obviously it will be considered under pari materia, because they are based on the same subject. Yes. So it is these sections go under pari materia with each other, and it is applicable in both Indian law and English law. So the concept of the doctrine of pari materia is a useful tool for the interpretation of statutes that work towards the same objective. It is therefore an established rule of law that all acts in pari materia are to be taken together as if they were in one law, and they are directed to be compared in the construction of statutes, because they are considered to be the framed upon one system and having one object in view. As such, we have come to the end of the video. It's riddle time. Please answer the riddle in the comment section. Please like, share and subscribe my channel for many more interesting topics. Thank you.